So here you are drafting your trust and you're thinking, hey, why don't I just have a catch-all provision that makes sure that everybody in the future will be benefited from this trust? I don't want to make sure I exclude people or include people I meant to exclude. So you say, all my future grandchildren, or something vague like that. Well, unfortunately, in Texas, up until recently, you could not do that and your trust would be invalid. However, a recent law permits that, and I wanted to talk to you today about that. So you can find me on my website, www.legionlawpllc.com, if you have any questions on this or anything else. But these trusts are now permissible. It is now permissible to put in your trust some vague, unascertainable beneficiaries. There's a huge asterisk to that, though. There are a couple concerns because it creates a certain type of trust that Texas is not a huge fan of still. It's permissible now, but it's not ideal. You should try to avoid that as much as you can. So, in other words, the Texas law will permit it to happen. You still will avoid probate, but you may run into additional problems that I can't really dive into more right now without making this a 20-minute long video. Essentially, you should talk to an attorney to make sure that the standard that you're setting is good enough to include the people you want, but not so broad that it causes a whole myriad of headaches. That being said, there's another asterisk to that, and that's actually with retirement accounts. So this is going to be interesting because in Texas, or in the federal government says, at least right now in 2024, that if you have a retirement account and it goes to a trust, that trust has two options. Well, two paths that we have to figure out. The first path is that trust must distribute all of that money out to the beneficiaries within 5 years. And that happens if we have unascertainable beneficiaries. So as I mentioned earlier, you can still do this, but you may be in the 5-year time frame, which would be less than the second path, which is the 10-year time frame. If you have ascertainable beneficiaries, meaning you can say John, Sarah, and Becky, we know those three people. We can identify each one. We can ascertain who is who. If we can do that, then it's actually 10 years for John, Sarah, and Becky. So that may be a huge difference because these required minimum distributions on retirement accounts actually can affect your tax rate. So if I have a 5-year time frame, I have to distribute more cash faster, and that more cash is probably going to bump me up in income taxes, and I'm probably, as a beneficiary, going to pay more in taxes because we have a 5-year time frame. The 10-year time frame, on the other hand, makes it so that I can have 10 years to take only 1/10 every year and lower the amount of cash I get as income, and therefore my income doesn't bump up nearly as much. It only goes up a little bit. I pay a little bit less in taxes. So there could be tax consequences as well to having an unascertainable beneficiary class. So this new law, it permits you to do something that may be not ideal, to be quite frank. And I don't see why many people would want to capitalize on this, but that's totally an option, and you should definitely talk to an attorney if you're interested in making an unascertainable beneficiary class, such as all my grandchildren, or anybody in Texas, or I don't know, the Queen, or whoever's in charge of the presidency, whatever, right? So if you have any questions on this and the tax consequences and what comes up later, I would definitely talk to an attorney like myself. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can go to my website, www.legionlawpllc.com. You can go to the Contact Us page and schedule a phone call with me directly, and we can chat over about this for free. So thank you so much for watching, and have a great day.